Okay, let's unpack this. Today we're diving into, well, the really complex mechanics of building a global career. Specifically, we're going to focus on that essential mandatory link between international work visas, things like the UK skilled worker visa, the US H1B, and the absolute necessity, really, of mastering compensation negotiation within those, let's face it, highly regulated systems.
It really is a double challenge, isn't it? You've got to satisfy the legal system first. That's non-negotiable. And then, only then, can you really start thinking about maximizing your own economic return.
Right. Fail that first hurdle, and the second part just doesn't happen.
Exactly. And the path, particularly in the UK, it's full of very specific financial hurdles.
So our goal here for you listening is really to break down these dense rules, turn them into a practical plan. This isn't just about hitting the minimums for immigration. It's about understanding the actual levers like the salary floors, the job codes, and using that specific knowledge to, well, strategically negotiate your whole package, everything from base pay right through to, say, your holiday time.
Yes, understanding the system is your first negotiation tool.
Okay, let's start with the UK then. On the surface, it seems kind of simple. Get 70 points, right?
Yeah, if only it were just that.
But the real complexity, it seems, is buried in the mandatory criteria.
Yeah.
Skill level and, crucially, salary.
Precisely.
So on the skill side, they use this RQF thing, Regulated Qualifications Framework.
That's the one. Your job generally has to be RQF level 3 or higher. Think A levels or equivalent technical certificates.
But for most people listening, probably developers, engineers, analysts, we're talking higher than that.
Oh, definitely. Most professional roles are RQF level 6 or even higher. That's basically graduate level. And that RQF level, it's directly tied to the financial gatekeepers, the SOC codes, Standard Occupational Classification.
It's 4-digit codes.
Yes. And what's fascinating here is just how fundamental that code is. It's not just about skills. It dictates the minimum salary for that specific job, the going rate, they call it. And it also flags the jobs on a shortage list.
So wait, the job duties matter more than the title. If my title is Senior Widget Analyst, but my duties match a lower-paid SOC code.
Immigration will look at the duties, absolutely. The title isn't the deciding factor, the substance of the role is.
Okay. And that SOC code then leads to what you call the salary trilemma.
Exactly. This is key for the UK. The employer has to pay you whichever amount is higher out of 2, potentially 3 figures. First, there's the general salary threshold. That jumped up significantly in April 2024. It's £38,700 now.
Wow. Okay. That's quite a jump.
It is, but you also have to meet the specific going rate for your SOC code.
So you need to hit both the general minimum and the job-specific minimum.
Well, you need to hit whichever one is higher. So if the going rate for, say, a programmer is £39,600, even if you meet the £38,700 general threshold,
you're still short for that specific job code. Application denied.
Instantly, yes. And these going rates vary a lot. Like you said, programmers might be around £39,600, but some medical roles, they're over £50,000.
So step 1 is research your SOC code and its going rate.
Absolutely non-negotiable research, but there are some important concessions, especially for people earlier in their careers.
Right, the new entrant category.
Exactly. If you're under 26 or you're applying just after finishing a UK degree that qualifies, the threshold drops. It goes down to $30,960 or 70% of the usual going rate for the job. Whichever is higher, of course, but still.
That's a significant difference, a real bridge for early career folks.
It really is. And there's a similar reduction if your job is on the immigration salary list. Think certain engineers, healthcare roles, some IT specialisms.
They get a break too?
A slightly different one. For them, it's $30,960 or 80% of the going rate. Still helpful.
Okay, this is where it gets really interesting. And a bit scary, maybe.
Yeah.
What actually counts towards that salary figure?
Yeah, this is critical. The Home Office is incredibly strict here.
Yeah, it's to be guaranteed gross base pay, right?
Correct. Guaranteed. Things like overtime pay, performance bonuses that aren't guaranteed. Most commissions, they're typically out.
What about allowances, like London waiting?
Specific guaranteed allowances like London waiting can count. Or maybe guaranteed shift allowances, but they have to be absolutely guaranteed in the contract. And this strictness leads to a major new pitfall coming in April 2025. It's about employer loans.
Loans, like to help with costs.
Exactly.
Yeah.
Especially the immigration health surcharge, the IHS. It's expensive, so some employers offer loans to help cover it.
which sounds helpful.
It sounds helpful, but the Home Office will now deduct the repayment amount of that loan averaged over the visa's duration from your salary calculation.
Wait, what? So if the loan repayment drops, your effective salary below that £38,700 or the going rate.
Your visa gets refused, even if the employer was just trying to help you with the upfront costs.
Ouch. So you really have to scrutinize any loan agreement tied to your visa costs.
Absolutely. It's a potential trap, even if well-intentioned.
Okay, that's a fascinating, kind of worrying detail in the UK system. Let's switch gears. Let's go across the pond to the US. Different system, obviously, but you mentioned the core idea is similar. Protecting wages.
Very much so. In the U.S., the key mechanism before the H-1B petition is filed is the Labor Condition Application, the LCA. It's filed with the Department of Labor.
Okay, LCA. What does that actually do?
Its main purpose is to stop employers undercutting local wages by hiring foreign workers cheaply. The employer has to state, basically under oath, that they'll pay the H-1B worker the higher of two figures.
Higher of what?
Either the actual wage, meaning what they pay similar U.S. workers in the same job, or the government set prevailing wage for that job in that specific location.
So the prevailing wage is kind of the U.S. equivalent of the U.K.'s going rate.
Broadly speaking, yes. It sets the minimum floor based on the occupation and the geographic area. But the LCA adds another layer you need to understand for negotiation. The prevailing wage levels.
Levels. Okay, break that down for us.
Sure. The prevailing wage isn't just one number for a job. The Department of Labor breaks it down into 4 levels, level 1, 2, 3, and 4. Experience, complexity of the job, how much supervision is needed. Level I is basically entry level, someone just learning the ropes. Level 4 is for, real experts managing complex tasks, maybe supervising others.
I think I see where this is going strategically.
Exactly. What often happens is employers might try to classify a role, even for an experienced person, at level 1 or level 2 because the corresponding prevailing wage is lower.
So if I have, say, 5 years experience and the LCA puts me at level 1.
You should be asking questions. Level A assumes pretty basic understanding. If your actual duties and experience are more advanced, you might be looking at a level 2 or 3 wage floor, which would be higher. You could be getting legally underpaid relative to the intent of the law.
That feels like a huge red flag. So when someone sees their LCA, which has the SOC code, the job title, the offered wage, and this prevailing wage level, what should they be checking?
2 main things. First, does the job description on the LCA actually match the SOC code they used? Sometimes employers might creatively describe a complex job to fit it into a lower-paying SOC code. That's miscoding.
Trying to lower the minimum threshold they have to meet.
Correct. Second, does the wage level, III or FLE, make sense given your actual experience and the complexity of the role described? If you're a senior person pegged at level 1, that's a strong signal to push back, even if the dollar amount technically meets that low-level I minimum.
Right, so it's about the code and the level matching reality.
Absolutely. It's about ensuring the classification is accurate, not just convenient for the employer's budget.
Okay, so let's assume you've cleared these hurdles. You meet the UK going rate or the US prevailing wage at the right level. The visa looks secure on the salary front. Now the focus shifts, right, to the total compensation package, especially for international moves.
Yes, exactly. If we connect this to the bigger picture, especially for true expatriate assignments, the base salary is just one piece of the puzzle. The whole compensation model often changes. Companies frequently use specific expat pay structures. One common one is the cost of living allowance, or KILALE approach.
What's the goal there?
The main idea is to maintain your purchasing power. So basically, your lifestyle shouldn't suffer just because you moved from, say, a low-cost home country to an expensive city like London or New York. The CLLA aims to bridge that gap.
Okay, so it's an allowance on top of base pay.
Good.
What else might be in an expat package?
Oh, quite a few things, and these are often very negotiable. Besides CLLA, you might see a hardship allowance.
Hardship? For what?
For moving to a location considered difficult, maybe due to safety concerns, lack of amenities, extreme climate, political instability, it's usually based on indices from firms that rate locations.
Okay, what else?
Housing is a big one, either a housing allowance or a company-provided accommodation. Transportation support, maybe a car allowance or covering public transport costs, and very importantly, if you have kids, educational assistance.
To cover school fees.
Yes, especially the difference between home country schooling costs and potentially much higher international school fees abroad. This can be a huge financial factor for families.
So lots of moving parts beyond the base salary, which brings us back to negotiation.
Mhm.
You mentioned earlier, data shows many H-1B workers just accept the first offer. Why? Why this reluctance to negotiate when you're on a visa?
It's often fear, I think. A feeling that your visa status is precarious, that rocking the boat might jeopardize the whole thing, so people feel they have zero leverage.
But that leads to problems down the line, right?
Absolutely. It leads to chronic underpayment. And because future raises are nearly always percentage-based, starting low means you stay relatively low throughout your time with that employer. Wage stagnation becomes a real issue.
So the key message is, your visa status does not take away your right to negotiate for fair market value.
Not at all. You still have skills, experience, and value. The visa is a mechanism, not a reason to accept less than your worth.
So how do you counter that fear? How do you negotiate effectively?
Your best weapon is data. Cold, hard data. You can't just feel you deserve more. You need to show it.
Where do you get this data?
Look for reliable, industry-specific salary surveys for the region you'll be working in. Things like MGMA data if you're in healthcare, or maybe Radford or Sullivan-Cotter for tech and other sectors. These give you concrete numbers based on job function, experience level, and location.
And you need to look beyond just the base salary number.
Definitely. Price the whole package.
Yeah.
Things like health insurance quality, retirement plan matching, that education allowance we mentioned, these benefits often add up to 20% or even more of your total cash compensation value. Don't ignore them in your assessment.
Okay, data's key. What about timing? When's the best time to negotiate?
Your absolute peak leverage point is during the job offer stage. Before you've accepted anything, that's when they want you most.
And if you're already employed?
Then the next best times are usually during performance reviews, especially if you've just had a really good year, or, as one source put it rather nicely, when the sun is shining, on your contributions maybe right after you've successfully delivered a major project.
Makes sense. Strike while the iron's hot.
Exactly. And always try to start the negotiation early, ideally before they draft the formal contract. It's easier to shape things before they're set in stone.
And given that sponsoring someone for a visa isn't cheap or easy for the employer, there are fees, legal costs, time involved.
Right. You need to frame your request strategically. It's not just, I want more money. It's, here's the value I bring, here's the market data, and retaining me, even at this higher rate, is a better investment for you than the cost and disruption of replacing me.
Document your value proposition.
Meticulously. You need to show why you're worth the investment, including the sponsorship costs. Remember, replacing an employee costs thousands. One estimate was over $7,600 just in direct costs, never mind the lost productivity and training time. Your documented value counters that replacement cost.
Okay, what if they won't budge much on the base salary? Maybe because of those strict visa rules we talked about.
That's when you pivot to negotiating non-salary benefits. Paid time off, or PTO, is often highly negotiable.
More holiday days.
Yes. Or maybe more flexible working hours. Or perhaps additional floating holidays you can use anytime. If they can't increase the base, ask for value elsewhere.
What about this trend of unlimited PTO? We hear about that a lot, especially in tech in the U.S. Sounds amazing, right?
It sounds amazing, but you need to be cautious. It raises an important question. Is unlimited actually better?
Why wouldn't it be?
Well, research suggests employees with unlimited plans sometimes take less time off. There's no clear expectation or benchmark, so people can feel hesitant, like they don't know what's acceptable. It can become a psychological cap.
Huh. Interesting. Any other downsides?
A big one. Payout on departure. With traditional PTO, you accrue a bank of days. When you leave the company, they usually have to pay you for your unused accrued time. With unlimited PTO, there's often no accrual, so...
There's nothing to pay out when you leave. You potentially lose that cash value.
Exactly. It can be a significant financial difference compared to a defined PTO bank. So scrutinize those unlimited offers carefully.
Good warning. Okay,
Yeah.
Final point. You've negotiated, you have the offer, the contract is drafted, whether it's for $40K in London or $150K in San Francisco. What's the absolute last step?
Get a lawyer to review it. Always.
Always, even if it looks straightforward.
Always. These aren't just job offers. They are legally binding, often multi-year contracts, potentially worth hundreds of thousands over their lifetime.
And not just any lawyer.
Preferably one who understands not just employment contracts in that specific state or country, but ideally also has some familiarity with your industry, like healthcare or tech, and perhaps the nuances of contracts for sponsored employees. Going into a major financial commitment like this without legal advice is, frankly, short-sighted.
Sound advice.
Yeah.
Okay, so let's try and wrap this up. What does this all mean for someone navigating this? It really feels like success in global employment requires this dual mastery, doesn't it? First, you absolutely have to understand the bureaucratic plumbing, the SOC codes, the RQF levels in the UK, the prevailing wage levels in the US. These things set your legal minimum value.
They establish the floor, yes.
But then second, you need to use market data, timing, and negotiation skills to actually achieve your true market worth, which might be well above that floor.
Precisely. Knowing the rules isn't just a barrier, it's actually empowering. It gives you the foundation to build upon.
So knowledge is power, quite literally in this case.
It really is.
Okay, let's leave our listeners with a final thought to chew on. We've seen that the salary rules for visas, especially that base pay calculation, are pretty rigid. It's all about guaranteed gross pay.
Very strict, yes.
But other parts of the package, those expat allowances like hardship or housing, education support, even PTO seem much more flexible and negotiable.
Definitely more room for maneuver there.
So, given that tension, when you're negotiating an international assignment, where should your primary focus be? Should you prioritize maximizing that guaranteed base salary because that secures a visa and drives future percentage raises? Or should you maybe focus more on optimizing those non-guaranteed allowances and benefits, which might boost your immediate quality of life or maybe even offer tax advantages abroad?
Maximize the visa critical base or maximize the total lifestyle package.
Exactly. Base salary security versus overall package optimization. Something for you to mull over.